Howdy and welcome to the show. Cooper's Code examines legal issues and hits those highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Bill Veen, we will be examining his career, his contributions to the intersection of workers' comp and third-party liability, discovering liability in challenging cases, and the joys of trial. We are thrilled to have my mentor and former boss, Bill Veen, the legendary Bill Veen, here today. For those who have practiced law in California, Bill Veen needs no introduction. He is a legend in terms of the record verdicts that he has set throughout the various counties in this state and others. He is a brand name in terms of being a Veen-trained lawyer and someone who has offered tremendous resources to the plaintiffs' community. And without further ado, Bill, welcome to the show.
Well, thank you. I'm glad to be here.
As we go into background, I know that you had a different background in terms of getting the law than some these days. There are lots of people these days who, from a relatively young age, are working on grades and doing everything to get into the right schools and what have you. Can you tell us a little bit about your background, whether it was some reading that you got exposed to from your father or being in a motorcycle gang? What brought you to the practice of law?
Well, I came from the east side of Detroit, and actually college was the farthest thing from my mind. I guess you'd probably say I was a juvenile delinquent. I was a member of Satan Chauffeur's motorcycle gang. We were just kids that hung out and got in trouble. But I think the thing that actually set me off way before that was when I was about 6 years old, I had polio, and my legs were paralyzed. And I had bulbar, which is the worst you can get. It's either 1/3 die, 1/3 are pretty completely paralyzed, and 1/3 get out of it alive. At the time, polio was not noted as being something that you just got over. In other words, it's sort of like, I guess, HIV was. And people were leery of it because their children could get it, and they did not understand how they could get it. But they knew that if you had it, they didn't want you playing with their kids. So my father, who was a carpenter, would be doing renovations, and he'd bring back these huge boxes of books from Tom Swift to the Hardy Boys to everything else. And I was just 6 years old, but I was reading a book a day at the end of this period of time. And I was a little bit paralyzed in my legs, so it took a while to do the kind of sports that everybody else was doing. But as I went through school, really did not excel at anything. It was sort of like, I think my grade point in Grosse Pointe High School was 2.4, and that was considered to be a gift. And so I was not destined for college or anything else. So it was sort of a unusual events that then let me get into college and then into law school.
Do you have a memory of that in terms of being 6 years old?
Oh, yeah. Very, very clear. My mother was a nurse, and I jumped off of a haymow. Actually, I jumped off of a barn roof, and I hurt my neck, and she felt a fever. I was in Upper Peninsula of Michigan, so the only place they could take me was the hospital. So they did a spinal on me and said, oh, he's got polio. I started going into convulsions, and they thought I'd be unable to breathe. So they gave police escort to the ferry boat and then to Herman Kiefer Hospital in Detroit, where all the kids were, a lot of children couldn't move their legs. And so they'd be crying out at night. And the walls were lined with iron lungs. So it was really tough. But I went into convulsions, slept for 24 hours, and I was getting better right away. So we used to have wheelchair races. When I came back, it was very alone for a couple of years. Nobody would play with me. So I really got into reading.
There are people I've met throughout my life who've had, I'm going to call them near-death experiences, a disease, a cancer, an experience like what you went through. And it seems to manifest for some of them in the way they choose to live their life. They choose to live their life with intentionality. And you strike me as somebody who has done that. Do you think that that experience lent itself in any way to who you became?
I'm sure it did. I didn't think I was very smart. And I took the SATs. I surprised my principal. I got a 98 or whatever it was. It was a big surprise. They said they looked at me, they brought me in, they said, these things aren't infallible, as they held it from me. Because I looked like a juvenile delinquent. I had long hair, I had a motorcycle, pack of Marlboros in my T-shirt, like you saw in the old movies. So it was very unusual that this would happen. And I found out I could get to college. I could actually go into college. So I went into college at Michigan State University, and I did really well there. And then I took the LSATs and got into University of Michigan Law School. And it worked. One thing just sort of fell onto another, and I became much more interested in law. I mean, law drew me in.
This is in the midst of the Vietnam era?
Yeah, that probably contributed to my staying in college and law school. I had 7 years of 2S deferment. I was 25 when I took the bar and passed it the first time up. And all of a sudden, they were going to send me to Vietnam.
You ended up finding a different path and a successful military path, though.
Yes. First of all, I became a line officer with the Coast Guard. I was an ensign. They sent me to Yorktown, Virginia for about half a year, and you learned everything about being a Coast Guard officer. And I was sent to New Orleans, and I got a message one day. It said, we understand that you're a lawyer. Surprise, surprise. And our lawyer in Hawaii had to leave his post and would offer you the chance to become a full lieutenant, to go ensign, JG, lieutenant, 3 grades, double your pay, and go to Hawaii and be one of 3 lawyers for the South Pacific for the Coast Guard. And I said, I thought it was a joke. I thought it was very unlikely that anybody would they must have spent a lot of time on this message because I could not believe it could be real. So that included 16 weeks of moot court competition in Newport, Rhode Island, among the Marines and the Navy and the Coast Guard. Competition being you take a role in a trial, and then you take that role and then you'd be evaluated on your performance, or you'd be a member of the jury. So we were doing this in old mansions in Newport, Rhode Island. So it was really kind of a fun time. And then eventually took the Lurleen, which is a luxury liner, to Hawaii, because if you do a little research, you could find out so many things. I found out that there was a law that said you could demand service transportation between posts in the United States if they passed from one state to another. There was no distinguishing that you'd have to take a luxury liner. During World War II, I think, where people were using airplanes, the railroads wanted the business. So they put this law in so I could demand that they let me on the Lurleen. And we had several days of first-class accommodations on the way to Hawaii. And so then in Hawaii, I was one of 3 lawyers there.
Rough duty stations, New Orleans, Hawaii, the South Pacific.
Well, that was it, too. I used to joke that my flashbacks were surfs up. It was like being on the Admiral staff, and they promote you based on what their needs were. And you're outside CONUS, outside the United States. So all of a sudden, I found myself at 27 being a lieutenant commander in the Coast Guard because I could do conscientious objector evaluations, and you had to be 04 or above. And so I outranked all my OCS instructors. Many things we do. One is we do court martials. We'd argue cases to fairly high-ranking officers. And you had to judge your audience. So the other was we would go all over the South Pacific and visit all these different sites for long-range aids to navigation called LORAN before we had the satellites. And there would be 40 or 50 people in Iwo Jima and Marcus and Wetak, Wake. I was in Yap. I was in MAP. I was in, I think, Kwajalein and a few other places.
The experience that you got there, because eventually work our way towards trial law, because that's what put you on the map here in California. The experience you had in Hawaii trying these court-martial cases, how did you feel that lent itself to the development of your career?
Well, I think that was everything. I mean, I remember my first trial, they didn't teach you. They just threw you in there to try a case. You see the people typing, of course, our court reporters. But in those days, they had, you would say something and somebody would mutter the same words into a little microphone and a mask over their faces. So you say, ladies and gentlemen of the jury, I'm very glad to be here today. And you hear in the background, ladies and gentlemen of the jury. And all of a sudden, you'd lose your track.
Interesting.
So it was, you had to learn how to deal with that and to isolate your brain. And it was very satisfying because I was a lieutenant and then a lieutenant commander. And so was my buddy, who was also from University of Michigan Law School. And he was on one side and I'd be on the other side. They get to choose. And since I was much more compassionate than he was, his father was general counsel for General Motors, I would get to the defense, which in this case represented the people that they were trying to put in jail. And so he would then be the prosecutor. We did a lot of court martials, and the jury would be lieutenant commanders, commanders, and captains. and you'd be playing the case to them. There's certain things you wouldn't do. You'd have to show how your sense of justice corresponded to their sense of the good of the service.
Interesting. At what point did you end up transitioning from being JAG Coast Guard to being out in California as a civilian attorney?
When I finished up in Hawaii, I had a choice to either stay on and be head of a district, which would be like I'd be head of a number of lawyers and review court-martials and that sort of thing, or I could just get out. And so my then wife and myself decided to get out and grab a Russian freighter from San Francisco and decided we were going to go around the world by land. And this would be quite a long time ago. This is like 73 to 75. We started out with a Russian freighter, the Sergei Yesenin from Far East Shipping Company of Russia. The only passengers, Japan, then the Krasnoyarsky Komsomolets, another Russian freighter from Japan to Hong Kong and Bangkok. And by that time, you might as well go all the way around the world. I guess why this is significant as far as law is concerned is that you're with people that you cannot necessarily communicate with words. You have to see them and feel their emotions, because some of them might be hostile. You have to parse out those people that might want to kill you from those people that don't. And since we were going around the world, I hitchhiked from one end of Malaysia to the other to Singapore and then back up to Kuala Lumpur, and I lived with an ex-cannibal tribe in Sumatra. We went from Sumatra to Java and then lived in Bali for months at a time in Bali. Then we decided to go on from there to Ceylon, which is Sri Lanka now. And then they were expelling a bunch of Tamils, and we went with the Tamils to India and made our way by a third-class train all the way to Nepal, lived in Nepal for a while, and then from there back into India and Pakistan, and then Afghanistan by land.
Not many people, I think, have had the opportunity to do that, given that country has had, whether it's Russians or the Taliban or the United States, it seems to have been occupied a lot of the time.
Oh, yeah. They really value honor. You get a continual barrage of people's customs, which you have to honor and you have to respect. And you have to not only do that, but show them that you're interested in their lives. And you are. It was a wonderful experience. I was in Iran before the revolution, just because we were us. And you really had to watch out for a volatile situation because we had basically taken away their democracy. So, living in eastern Turkey, in Erzurum, and then back to Istanbul, hitchhiked along the coast, went to Greece, and eventually Europe and over the Alps, and a whole year had gone by. But I guess why this is significant as far as law is concerned is you see people, they all want their family, they all want to be healthy, they want to possess power over their existence. You see what really is important in life and how you can reach them so they won't hurt you or steal from you, but also so that you can communicate with them. And so I think more than anything else, that year was an education, tremendous education for law.
So if I'm reading between the lines, you got a doctorate in jury selection and the joy of travel for a year. Is that?
Yeah, it was about a year and a half, actually, by the time we really got back to California. And so it was a round trip, so to speak. And then I got a job with a plaintiff's PI firm. It's called the Bicardo, Blum, Lowell, Nyland, Teerlink, and Bell, and got really proficient in workers' compensation.
Did you only do workers' comp, or did you handle other matters? And the reason I ask is because it's evident that you did a lot of jury work in JAG, and comp doesn't have that jury component.
True. Yeah, most of it was comp. In other words, I became a legal specialist in workers' compensation. I found, though, that I could give a closing argument, have an effect on a judge, just as you would with a jury. They're just people. And it became, if you were able to handle 400 comp cases, which I was assigned 400 comp cases, it was almost a joke. You want to go away for a couple of days and you come back and your desk is a foot and a half tall with cases. You learn how to deal with people. People are hurt. They come to you and they hope that they're going to be taken care of. And the comp system doesn't compensate adequately. So I learned a lot from that. Actually, what happened was I spent a year drinking, gambling, and smoking cigarettes. We gambled down in one of the lower levels of number 1 California. Firm was there. And the idea was a lot of camaraderie, male camaraderie, and that sort of thing. I realized a year later that I had broken even. And I had spent all this time and all this energy doing nothing. And I realized that I was going to probably get killed by the cigarettes too. So I decided I was going to start my own practice. You can do a lot if you don't know anything. I mean, if you don't know the barriers to success, you just walk in and you say, okay, it's going to work out. And so when I started out, it was with an absolute absence of knowledge.
I understand what you're saying when you say that. And I would also say that the background in JAG, giving you trial experience, seeing a little bit of how a plaintiff's firm operates, gives you at least some understanding so that you're not completely crazy going out on your own.
Well, it wasn't so much going out on my own. It was the idea of having an office, having obligations, set up files, having systems, and all that sort of thing. And I lucked out. I got set up by a former legal secretary. When I first started, I had $50 a month rent for a desk in another attorney's office and no secretary and no help. And then a month later, I started getting business to the point where I had to hire a secretary, and she sat in the chair, and I stood up, and that went on for a while. And then finally, a little 3-room office for $130 a month opened up with the kinds of windows that are kind of like, that open like this.
For our listeners, sideways, you mean?
Sideways,
yeah,
onto a little courtyard with some plants and everything. It was very, very Sam Spade type office. And bought a bunch of furniture from the March of Dimes, and at night, refinished furniture in the basement. I bought it for like $50. So I had cabinets, and I had desks, and everything like that. And my then wife made batiks, which covered the office, made it very hippie, but it worked.
And this is 1975. And for those who are listening who went to Hastings, your office was located where the now Hastings Library is?
Yeah, 228 McAllister, where the Hastings Library, rather, is presently located. So all of a sudden, I got dispossessed, you know.
As you talk about refinishing furniture, do you still work at a desk that came from that period?
No. So I found the top of an English desk that was like 200 years old, and they said, well, we're very valuable, but we don't have the bottom of the desk, but we'll sell you the top of the desk for $600. And so I bought that desk. And about 6 months later, I came back. If we had the top of the desk, we'd be able to sell it for a lot more money, but all we got is the bottom. It came in another container. So I bought the bottom and the top, and then I had this desk that's about 5 feet by 4 feet, and it has a inkwell for the partners. Used to be a partner desk. So it'd be a partner on one side, a partner on the other, and a secretary in the middle. And so that desk has been with me for, 48 years, 49 now. That was the business. And the business actually just kind of took off. I don't know, but I was doing mostly comp then.
And I want to pursue kind of dual tracks as we're having our conversation, because you've had success in two areas. One, you're a top talent trial lawyer in terms of the verdicts that you get. But the other is, for 48 years, you have been a business operator. And it's unusual where people can do both well. Usually you're one or the other. You're a good entrepreneur, you're a good trial lawyer. As you looked at your experience at Picardo and some of the challenges that you saw from the interactions there, and I'll let you fill in any information that you care to, did you make conscious decisions about how you're going to approach your firm?
Yes, very much so. Cut down on the drinking, no smoking, no gambling. The idea was we could provide people with, first it was mostly comp, but at Picardo I did learn the interface between workers' compensation and personal injury. And if you looked at the CEB book for California, whoever wrote this has no understanding of the law, because what they say is someday you will see a case which has a potential for personal injury and one for workers' comp. You have to choose which one you want to go. And I'm going, no, you get both. Usually you get both. In other words, I've had a case where we're able to knock out a $500,000 workers' compensation lien because of the employer negligence, which you can do, and still get the guy over $10 million and new money. I'm just saying that when you learn that, inherent in many of the workers' compensation cases are viable personal injury cases that have value of maybe 10 times more than the workers' compensation case. One thing I knew, I didn't necessarily know how to do it very well, but I knew it existed. So I kept my eyes open.
And in keeping your eyes open, I'm seeing somewhat of a theme, and we'll probably talk a little bit more about this if we talk about some individual cases where you've made changes in the design of supertankers, for example, because of what you've figured out. The theme I'm seeing in terms of how you approach things and how you have kind of become the go-to resource for maximizing third-party comp overlap. That's something I think you're known for. Is that fair?
I'd say that's fair, yes.
And is that in part because of your ability to dig in and find things that others don't?
Yes, I think that workers' compensation is something that's a statutory benefit that people get, and the workers' compensation attorney sees it only as a workers' compensation case. If it's an auto case, if it's a premises case, they may say, oh, maybe I should get a personal injury lawyer involved in this, but still never really recognizing the potential interface. By interface, I mean, when the Veen firm gets a case from a comp attorney, we take that case and we work collaboratively with the comp attorney and make sure he's not stiffed, which they get stiffed all the time by personal injury attorneys. Then we agree to try the credit trial. In other words, you can sweep up a bunch of money for the third-party case, but you leave the guy high and dry as far as his future medical is concerned. That's not fair.
Can you explain what a credit trial is on the comp side?
The credit trial is such, the workers' compensation people want to get their money back, and the secondly thing, they want to not pay money in the future. They get their money back by filing a lien until there's an allegation as they're accused of employer fault. And then you're suing a third party. They have to then file a complaint and intervention, so they are a party to the third party case. Otherwise, they lose their power to get their money back. So a lot of them get scared off because they may get hit with costs and various other things, and they just fall back on the potential of asserting a credit, which is done in a workers' compensation forum. And the credit is this: we have paid enough. We should not have to pay anything more. And sorry, you may need medical care, you may need all those other things, but you don't get them. And what we do is make sure that we protect the worker on both forums. Okay, does that make sense?
It does.
We will go in there with our knowledge of the case, having taken all the depositions and everything, and find employer fault sufficient to knock out any claim they have for a credit in the credit trial. Okay, it's called a row proceeding. It's like if you show that the case is worth, say, $5 million and that there's 20% employer fault, there's a $1 million cap that has to exist before they get to claim credit. So if they're still at 100, they'll never get to that point if you do it right. And so we rarely pay comp people back their money. It gets a little more complex than that, but that's basically it. That's why most of our referrals come from comp attorneys and from other attorneys, and we, of course, pay referrals and what have you. So you have to be proficient in workers' compensation and also then proficient in personal injury to recognize that interface and to make it work to the advantage of your client.
At this stage with the Veen firm, have you made a conscious decision not to have your own comp wing so that you don't compete with the people who refer you cases?
Yes, that came up a couple of times where they said, why should we give you this case when you're going to be our competitor? And you'll just draw cases from the union that'll go to you and it should go to us. And so we make it a point, we just handle the personal injury cases, but we work with that comp attorney and we can manipulate the comp process and the depositions that occur in comp to bring the cost down, for one thing, but also they're here kitty type things that they don't even see it's coming because it's coming from behind them. It's coming in the workers' compensation forum. It works out to the benefit. So at the end of the day, comp attorney gets a substantial referral fee on the PI because they do their work too. And we don't wipe out their claim for comp fees. And we get the client the money that he'll need in the future for medical and for other care that he might require. So it's a sort of a win-win situation. That's why I was so critical of the CEB book, The Continuing Education of the Bar, which was written by somebody that had no knowledge whatsoever about the fact that there are mutual benefits in these cases of PI and comp. And every comp attorney worth their salt should look at a real serious injury case and say, is this potentially have a personal injury aspect?
I think for some people who don't understand kind of the granularity of personal injury and workers' comp is that workers' comp doesn't provide non-economic damages. And it also, in many cases, it's about 5 cents on the dollar for the losses that somebody suffers. So when you're talking about leaving money on the table, the quality of life that an individual is going to have when they have somebody who maximizes dual benefits, comp and personal injury, is going to be completely different than if it is just comp. Is that fair?
Very fair. For the record, for people that are unfamiliar with it, comp is a system where the person forgoes suing the employer. Now, there's a bunch of exceptions that I could identify, but Comp is a system where instead of suing the employer for its negligence, you get a benefit on a statutory level for each percent of disability and temporary disability at 2/3 of your wages up to a modest sum and some rehab benefits, so what have you. It's very cut and dry. It's like chopping meat or something. That's why it's a little boring, frankly, sometimes, because it's just one thing, one strain back after another. But they're not compensated. It used to be even worse. It used to be a very heavy lifting preclusion for a Boilermaker, might be a 10% disability, where the Boilermaker will never be a Boilermaker again. I mean, because he can't lift heavy. That's the nature of the job, or an iron worker or what have you. So what we do is, in a personal injury case, you get all of the benefits, all of the wage loss prospectively until the person would no longer be working. You get all of the medical care prospectively in past. You get vocational rehab benefits. You get household services, which can sometimes be hundreds of thousands of dollars because you have to hire somebody else to do your work, or you are unable to do the work at home. You can't lift, you can't bend, you can't stoop. Somebody to take care of your lawn. That's a benefit you get in personal injury. So you've got this one system of personal injury, which I'll call justice. And then you've got this other system, which is basically for the benefit of the employer and to not get sued. And so what happens is there's the exceptions that allow you to sue your employer, like power press exception, everything like that. I can go through a bunch of them. 2, there is then the third party cases. Someone other than the employer screwed up, okay? And they're legally responsible. So the employer will say, I want my money back. I want all that medical and all the care we gave you and everything else like that. And we basically show that the employer is also responsible and therefore is barred from getting all that money back. And so that's the finesse of the whole thing. And when you do it right, you end up getting the person justice, and you also get them put a bar on the attempts by the workers' compensation carrier to get its money back, or to a barrier for his getting medical in the future. So you've got a really happy, satisfied client and a very happy, satisfied workers' compensation applicant's attorney.
Now, with that as background, I think it would be wonderful if you might have an example or two of cases where someone may not have spotted the issue in terms of finding that third-party case, and any learning you can provide to people who are listening in terms of being better at issue spotting when they're doing things like this.
You got a couple of them, but I'll take one which Diane Feinstein's daughter, Catherine, tried, Conclave case. It was a case where my client was a heroin addict. Not a good start. And he backed into a open elevator shaft that was obvious. He backed into it. He only fell one floor, but he hurt his back. Non-surgical back. He was getting workers' compensation coverage, and a lot of people would just let it at that. He backed in, but no. Whose responsibility was it to barricade that? And we found the entity, which is the general contractor, had that responsibility contractually.
I think you just answered my question. You found it contractually. How did you find that?
Well, we obtained the documents, all of the contract documents. You've got your general conditions, for instance, and then you've got your specific conditions, and then you have all these different cituses where you can get information. You get the coordination meeting notes, you get the toolbox meeting notes, you get the subcontracting notes, you get the architectural information because they meet at the same time. So he'll make a note about something, whose responsibility it was. You get it all together and the site photos and everything like that. And then you figure things out from there. And in this particular case, my client was a very smart guy who happened to be a heroin addict. And they were just sitting there salivating. They offered $150,000, even though it was a career-ending injury as far as I was concerned, because they're going to spring it because he was not exactly candid about his being a heroin addict who's on methadone. And right before the doctor's depot, I found the information. I said, no, this is wrong. This guy he may be functioning addict, but he's an addict. And he's not telling that. And I went to the guy, he said yes. And I went and saw the doctor and I said, does this make a difference? And we basically established that the doctor now knew this before he had his deposition taken. So anyway, I'm in trial, and the idea was that he thought it was worthless. I thought it was worth millions of dollars because he had the differential of income for his entire future had significant multi-million-dollar characteristics, and he had medical care and he had everything else. And his life was pretty well shot at this point because he was struggling. So when I asked the jury, I specifically said, how many of you believe in redemption? that a person can look at their life and see their death and see the destruction of their existence on this planet and change? Or do you feel like once an addict, always an addict? And I chose the people that believed in redemption. And the whole idea was this was a guy that was struggling against all odds to be something, and they took that away from him. And so I was able to establish the identity of the miscreant, and I did it in terms of time. What, comparative negligence? I had a big clock, how many hours they had to alleviate the hazardous circumstance they were aware of, and how much time he had from the time he took that step backwards till when he fell into it. And it was something like 100 to 1. So he got 1% comparative negligence, and we got the rest. We got $10.6 million for him, which helped him a lot. And that's why I just say another case that's similar, where you wouldn't even think there's a liability, was a case with Travis. I tried it in Marin, and he kept banging his head on scaffolding. And he banged his head, and 2 jobs later, he was dropping wrenches and stuff like that and having neurological problems. And it was found that the disc had actually centered on the cord, and it compressed the cord and caused death of some of the tissue in the cord. And he was permanently had bowel and bladder problems and everything else like that. Really horrible existence because of consequences. So, a lot of people would say, banged his head on his scaffolding. That's it. It's just workers' compensation. But it wasn't, because the general contractor had an obligation to follow OSHA. OSHA requires, as a matter of law, that you provide an avenue of entry into a job site that is free of debris, well lit, and no barriers over 7'6". Okay, this doesn't happen, and so they offered again a couple $100,000 max, and we tried that case against. It was basically a medical issue. How he never saw a doctor, so therefore the doctor says, their expert says, well, it didn't happen. Had a bunch of medical records. I said, what if he had gone to a doctor and the doctor had noted that he kept dropping his tools at such a date? And before you give a decision, what if another doctor saw him when he had burning hands and therefore he had to put it in cold water? That would be a neurological sign and symptom. And I went through a bunch of things, and he says, well, then I guess there would be causation. And so I said, but what if it was just honest human beings that you believed that saw what I just reported? It wasn't a doctor, but it was a person that you believed. Would you say that the same neurological symptoms were in existence and that causation was established? And voila, it was like, I think he thought that I had all the medical records in my hands, which were actually somebody else's medical records. Anyway, he got justice. But the nice thing is he also got workers' compensation. He got $11.6 million for compensation in the personal injury case, and then they found 20% responsibility on the part of this was after, as you know, you get all your specials, and then the generals are eroded by the negligence of the employer. So 20% of that generals we lost, but still got $11 million. And the 20% would be multiplied against $11.6 million, so you got at least $2.3 million of barrier to them getting any money back, and their credit is completely destroyed. And so he got all those benefits in comp, and he got all the personal injury benefits. So he kept the case, and it's just an example of, when you scrutinize the injury and the method, what happened, it's not just one person. On a construction site, you have coordination meetings. If somebody gets hit by a bolt or something like that, it's somebody's fault because somebody coordinated so that one trade is below another trade, for instance, and you have a case. Case after case after case after case. When I go to a comp firm and I say, what's the biggest case, the most serious injury? And let me scrutinize that. And voila, we get it and we win it if we prepare for it as we do. And cops guys might get a huge recovery in the PI aspect because they worked the case. They should be rewarded as well.
I want to talk about the preparation piece for a minute. And here I want to go to depositions. One of my memories when I was knee-high to a grasshopper, in terms of working with you, was working outside the conference room as you were preparing for a deposition and watching you assemble a person most knowledgeable deposition in a case like this, where you had received all of the documents that you just discussed before, and you went through them all, and you would then put them into a format where you were able to peel that person most knowledgeable like an onion. Can you talk a little bit about your methodology and how you developed that and how you taught it to others?
In every case, the most important thing you can do is get the information, get the documents, get the contractual material so you can prepare yourself for the deposition. But also, it's sort of like if I asked you a question, say you're a general contractor, I say, would you have a responsibility to ensure that people have a safe access to the work site? You would get a response that say, no, I delegated that. I don't have anything to do with that. That's another carrier. That's the guy's employer is always responsible for identifying the hazards, and he should never allow his employee. So you have to do it here, kitty, kitty. Here, kitty, kitty would be you'd have the same documents. You start out with saying, you're the general contractor. I see all these books here, and I see some of these things deal with your trade. And you have to have a license, and you have to have a license, and you have to be knowledgeable about all this. I understand that over there's Office of Safety Health Administration regulations. Is that something? Are you tested on that? And so you couldn't be a general contractor unless you had a really encyclopedic knowledge of this material. That's right. And so one of the things here, I note that you delegate to people. You can't do the whole job yourself. So you have subcontractors, and the subcontractor, you do these coordination meetings so that make sure that the subcontractor isn't locked outside your establishment waiting to get in. So basically you make sure that he can get in. Can't do much if he doesn't get to his site. Now, an elevator constructor, he doesn't build an elevator right across the building. He builds it in a location, right? So he's got to get from the outside of the building to the inside. And that's what you want to make sure that he does that, because otherwise you're going to get the benefit of his work. And so you have a responsibility anyway. You might make responsibility very quick. You have a responsibility to make sure that he gets from the outside of the building to the inside of the building where he's going to do this. And that's called access, right? And when you say you have that responsibility, you're talking about a responsibility for safe access. Isn't that correct? And by safe access, you would agree that safe access would be in accordance with the laws of the state of California? So your responsibility to provide safe access according to the laws of the state of California, would that include OSHA requirements? Well, yes. That means your responsibility to provide safe access within the building to a subcontractor would include OSHA so-and-so and so-and-so, which says that it has to be well lit and free of debris and no impediments vertically under this. And that's your responsibility as a general contractor. Yes. Never get the same answer if I did it the other way, right? You can see what I mean. You'd never get it. You'd have to do it here, kitty, 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 kitty. You slowly build it up. There's no way out of that. They can't go back. So anyway, that's how I would prepare a person. First of all, expand on their knowledge, expand on their experience, expand on their expertise, and puff them up big time so that they are, in the words I guess I would use would be, you understood, you recognized, you knew that part of your knowledge bank was this, things that they don't want to say, I don't know. They don't want to say, I didn't understand, because they're general contractors. You've puffed them up so much that by that time, they're not going to say, I don't understand. When you say you understood, they'll say yes, almost always. I don't know if that covers some of the areas that we're talking about.
It does. It gives a very good foundation for understanding how to take someone who might say no into not just saying yes, but saying yes in a way where they've been boxed in. The next question, though, would be, how do you handle that person on cross-examination, 776 examination at trial? And by way of background, one of the things I remember learning from you is don't hate them until the jury hates them. So I know that most lawyers, I think at this point in their career, recognize that the TV show demeaning lawyer, aggressive, nasty cross-examining lawyer doesn't necessarily get where they want to go. But even with that as a background, I think some people think that they need to be aggressive in cross. How did you tailor your crosses to be effective with that same witness as an example?
Well, most of it would be, let me understand. Let me understand, because you're the expert and I'm not. Let me understand how this works. And there's not as much resistance to that. And you don't hate people. I mean, in this business, you're an idiot if you hate people. You never want to be more aggressive than the least aggressive member of your jury. In other words, you just want to know. You want the information. And, how could something be avoided? If they're arrogant and they're nasty to you, then that helps you. And also just as a general human consequence, being nasty takes a lot of effort. you really do get people, like I think I told you about that ship, the designer. He said, all right, I would have designed it differently. Is that what you want? And I said, yeah, that's what I want, you know? But the thing is, you don't have to be an idiot. You don't have to be aggressive. I look at aggressive defense lawyers as a gift. You know, the ones that are dangerous are the ones that are nice.
Yeah, that makes a lot of sense. I want to make sure that people who are listening don't think that they missed out on something. We had a conversation before we started about various topics, one of which was, and I alluded to it when talking about some of the changes that you've affected through your litigation, and that involved supertankers. Is that another example that you might be able to use in terms of being able to focus a lot of attention and visit the site in a way to be able to ultimately get a result for your client that other lawyers may not have been able to do?
Yeah, let me just tell you a little about the case ahead of time.
Sure.
This is a case where it was this double-hulled supertanker for hauling petroleum products. And it was huge ship. And the guy was found dead at the bottom of a ballast tank, falling some 60 feet. Nobody saw him fall. He just fell. And so that ordinarily that would just be workers' compensation. But unless you ask yourself the question, why did he fall? How could it have been avoided? Are there any structural components of the ship, any aspects of the ship itself that contributed? Because a ship is a product. A ship is not just a ship. You get injured on a ship and it could be avoided. The ship is a product. So I kept going to Philadelphia to take these depositions. And as I learned, Coast Guard has regulations as to when valves have to be inspected and removed and refitted. So there was a access ladder down into the ballast tank compartment. Now, a ballast tank fills with water when the ship is empty. For instance, this one would fill with water from the Chao River and ballast it out. Otherwise, the prop of the ship would be up in the air, you know, see? And then they pump the water out of the ballast tank when they fill it full of petrol. So he was in the ballast tank, having accessed it by virtue of this ladder. And to access the valve, which he was required to do on an annual basis, he had to get out of the ladder and then go through these various compartments, which had a pinch grip type of girder that went through it. So he could hold on, and he'd walk around these, they're called lightning holes. So this was all dry when I went there, and it had a very high coefficient of friction because the mud had turned into basically sticky or dirt. So you couldn't see it right off the bat as to why that would have any relationship to his fall. But as I found out, I basically established liability on the idea that if there's a safe way and more dangerous way, the more dangerous way gives rise to liability. I mean, if there's a safe way to do something and there's another one that's not so safe, there's no reason for them to have chosen the not safe alternative, you have liability. And what I focused on then was the idea that there was nothing prohibiting him from putting the ladder on the other side of the tank so he could just walk down the ladder, check out the valve, and wouldn't have to do this dance, I call it a dance of death, around these vertical fall potentials. But it was only after really getting associated with it and tracking this big, huge super tankers, there's like close to a dozen dead people at the bottom of this various ballast tanks. And nobody knew why, but they kept falling through the lightning holes. And so I tracked it down that what it was these had to be ventilated, but you couldn't have an electrical ventilator. You had to have water ventilators, and the water ventilators would leak. And when they leaked down onto the mud, which was now dried up, of the Chao River, it became slippery as anything because there was a Teflon base underneath that to allow the water to flow into the bottom of the tank so it could be pumped out. So all these poor guys would go there, they'd use the pinch grip of the girder and walk along, and there would be this drippy water onto the mud of the Chao River on the Teflon base. Their legs would go out, their pinch grip would not withstand the weight of their own body, and they'd all go down into the bottom of the tank, and they were killing people. And they had many of these super tankers. So by establishing that to be the cause of death and negligence, because they should have had some kind of a metal screen over the fall potential or stagger the lightning holes. In any event, they changed everything so that they protected the fall potential. They didn't put new ladders because it just would have required too much work, but it probably saved another 20 people's lives. I don't know. But I guess to me, if you're a real lawyer, you get down into the place where the person was damaged, was injured. You basically breathe the same air. You basically get on the same platform. And we did very well for that family. And we're otherwise on top of the workers' compensation.
Not just did well for the family, but affected change in a way that protected workers going forward.
Yeah, it probably saved another 20 lives. But I think we do a lot of that sometimes by making changes, because these defendants, they don't really care about anything quite often. I mean, I'm not saying everybody. I think there are some really decent people out there, but a lot of these big companies, it's the bottom line. How much is this going to cost us? For instance, all the fall protection that has been established over the years. It used to be people were falling out of the sky because they just didn't tie off. They didn't require tying off. And everybody's able to make mistakes. People were getting their hands chopped off because they didn't have barriers in the machines that they were using. That has changed because of plaintiffs' lawyers. Changed because of the compensation was more expensive to them than the precaution.
So there are carrots and sticks when one is creating things, and a carrot is to make a well-made product, and a stick is you may have made that product well, but this part of it wasn't. If you don't fix it, it's going to cost you way more.
Exactly. And then all of a sudden, they get religion, and they become very interested in safety. And the same thing with the parent corporations and the subsidiaries. The parent corporation is there to make money, to reward its stockholders, which are usually a rich cadre. And they have a subsidiary. And people get injured in the subsidiary, and they think it's just workers' compensation. And it might be. But if the process was refined by the parent corporation, and it's a hazardous process, or they send it down because it's not profitable, but they don't train the people that are now going to be doing explosive loadings, which I've had cases where the initiators of airbags were sloughed off into another company, and that company wasn't properly trained. The people weren't trained, and all of a sudden an explosion occurs, and everybody thinks, oh, it's just workers' compensation, but it's not. The parent company is not protected by workers' compensation. And there's a lot of that. There's a lot of those interrelationships between companies where one of them is unprotected. By unprotected, I mean they can't use comp as a shield against personal injury liability.
I'm picking up on a stay curious / Columbo almost in terms of the way in which you recommend lawyers look at fact patterns that are presented to them.
Yeah, sometimes it takes a lot of digging. The case of there's a metal bridge between digesters in a sewage treatment plant that the employer never even bothered to look at for 25 years. Never looked at it. And a guy comes across the bridge, and the bridge collapses, and he falls down and becomes a partial paraplegic. He's got workers' compensation, but does he have a personal injury case? Because you think, oh, he has workers' compensation, big deal. But what about the loss, the general damages, the damages to your person, the actual compensation for household services, actual compensation for all these things? And you're looking for somebody else, but nobody else was there. There was a company there that whose job, that basically go from place to place, and they say, hey, we'll give you some safety education and we'll take a look around. Okay? And they took a look around and said, yeah, it looks okay to us. Boom, legal responsibility. Not a large percentile, but any percentile gives you all your special damages.
You mentioned this earlier, and I think that for many lawyers who do this, this is known, but this is the Prop 51. Economic damages, special damages are jointly and severally collectible, even if the employer is 99% responsible and the other person's 1%. Is that fair?
That's fair.
And I'll say I learned that from you.
I tried that case. I got 1% legal responsibility and 95% employer fault and 4% comparative. And that was before. This is in the 80s.
Wow.
Where everything was joint and several. So I got full compensation for the guy on 1% legal responsibility. Now you get full compensation for the damage to the pocketbook. There's damages to the pocketbook, and there's damages to the person. Damages to the person are your general damages. Damages to the pocketbook are all your economic damages. So 1% liability gives rise to several $1 million of legal responsibility, and it would bar the employer from ever getting any money back on its lien claim or its complaint intervention. So, I mean, it's worth taking a long look at. I mean, just ask yourself, what could have been done to preclude this event from happening? And in the case of the platform that collapsed, you find that somebody was there and said, hey, gave it the imprimatur of, hey, it looks okay to me. But at the same time, I have photographs I was able to find out that have in this case, the Anthony Label found out, that we benefit by our cohorts, who found rust streaks coming down from the bridge, which, although the employer should have found them, this entity said that we look around and give you the stamp of approval. And so, they laughed at us initially. They had $1 million policy, wouldn't pay the $1 million, and then ended up paying about $8 million, I guess, all specials, but all the damage to the pocketbook.
Going from $1 million policy to paying $8 million, that sounds like you might keep a bad faith lawyer consult on speed dial.
Oh yeah, definitely. I mean, we've done that many occasions. Sometimes if a PI lawyer who knows the stuff comes to a comp firm and just says, show me your biggest case. All of a sudden, there's a case and there's a referral, and the comp firm might make as much as 25 workers' compensation cases just based on the referral. It's like telling people, to a carpenter, everything's a nail, and to a comp attorney, everything is a workers' compensation case. And they've been taught somehow only to look at certain types of cases, but without the kind of vertical responsibility I talked about, sibling responsibility of sibling companies, products where you wouldn't know there's a product, but because of is a ship a product? Yeah, it very much is. So many of these things you find by digging, and all of a sudden you've got it. If you've got 1%, you've got a case worth taking on a real high injury case, high cost case as far as medical and what have you.
Switching gears a little bit, I know from experience and observation at the firm that the firm works with jury consultants, does focus groups, does other things. I also know from having sat and watched you try cases that you typically would pick a jury yourself, and you would not necessarily have a consultant with you while you're doing the jury selection. And I know that different people feel different ways about that. Is there a reason you went that direction instead of having somebody, at your side telling you this one, not that one, not this one?
I've been retained as a jury consultant. That's the one thing.
Okay.
There's all kinds of characteristics of people that you can see. When I mentioned that we're traveling around the world, I think I spent probably a total of $6,000 over a year and a half to talk about people could hurt you. If you have goods and services, they'd like to take them. So you really have to read people, and you have to, and you learn quickly doing that. I think I know a lot about how people behave. I can see in a sense, your life is written on your face. I mean, you can see people, and this is a joke about the RBF, the idea that a person's face is really set. If you had a photograph of someone that was a serial killer or something, or a person that was a mean human being, it sits with them. It sits with their eyes and the cast of their face and in their voice and everything else like that. So you can often pick people out that are not going to be empathetic. What you really want, I don't want a bleeding heart. I want someone with empathy. I want someone that can feel what my client is going through. And when I go to the jury and I ask them for money, I don't beg them for money, ever. Never. I don't ever say, oh, please give so-and-so money. You never do that. But you would say something like, you have a tremendous opportunity here to do something that will resonate over the course of decades. It'll change things. 20 years from now, you're going to get together with some of your friends that you've made here. You're going to say, we made a difference. We created something that wasn't there. We did justice. We had more power than a governor, more power than a legislator. We did justice, and we are proud of our verdict. And you could say that pride is a much better tool, in a sense, for them to just give my client money because he's hurt and he would benefit him. So I'm just telling you how I would do. And I've done many of these cases. Sometimes you don't think you can win, and they force you to trial, and then they offer $25,000. I've had that happen with a guy that lost his leg. Remember the Gordon case?
I do.
Yeah, he was hauled upside down into the shaft and up and two blocked against the descending elevator.
They offered $25,000 on that one?
Yeah.
Wow. Boy, did they make a mistake.
Well, They didn't see that I could sue, but I sued basically the manufacturer of the capstan winch that should never have been used to haul an elevator platform. 75-pound rails maybe, but to haul this elevator platform, I mean, you just do the math. And it's 5 stories up and it's 5 stories down. That's 50 feet. But it's a 6-to-1 rope fall to reduce the weight of the elevator so that it's manageable by hand. So a 6-to-1 rope fall on 50 feet, that's 300 feet of rope this poor guy is going to be operating around with a capstan winch that doesn't have power down, it only has power up. And he's using it to wrap the rope around, thereby getting better purchase on it. And then slowly letting the rope out. And if it loses a bite of rope, you've changed from 100 pounds to 300 pounds. And a human can't do that. So he stepped into the coil of rope and was dragged upside down into the shaft through a window. And the only thing that stopped that descending elevator was his leg, which peeled off. And who do you sue? The manufacturer of the capstan winch was the one that thought they'd make a pile of money by creating something that would haul cargo over human beings when there was no positive affixation of the cable. And so it was like, all right. When I tried the case, at the end of the case, I walked in with a bicycle helmet. And I said, yeah, who would ever say this bicycle helmet was defective? It's a perfectly good product. But if I sold it to you and you're driving a Harley at 75 miles an hour, and this is what you put on your head, it's defective for that purpose. And that's why you should pay my guy many millions of dollars, which they did actually. Although some might doubt his wisdom in using the capstan winch for the non-braked elevator platform as he did. But they were wrong. I get a sense of justice when I try cases. I really, you might say, well, that was a stupid thing to do, but people are fallible. They're just people and they'll make mistakes. And the job of a manufacturer or a company is to try to reduce that risk, to make sure that the people can use the product without dying, for instance.
Do you have a favorite argument for non-economic damages? There's, turn back the hands of time. There's dollars per day of injury as a second job. There are all sorts of different ways that creative lawyers have come up with over the years. Do you use different ones for different cases? Do you have a default setting? What is your preferred method for getting some of the record verdicts that you've gotten?
Well, sometimes you could just put it on a board. What was and would have been. And this is the trajectory of a human being's life versus what is and will be. And that differential, you can paint that with a magic marker. And you can say, this is what you have to compensate this person in order to do justice. It's not a negotiation. This is an application of your intelligence to a problem as to what would make the person whole. What would take the place of this? You'll never make the person completely whole, but you do the best you can. Look at this person. He can't walk. He's not going to be able to go hiking with his kids. He's not going to be able to do all these things. You have to give him back his personal power, his dignity. That's your job. Sometimes I do a big circle like this, and that circle will contain both the special damages, that means the damages to the pocketbook, and also the general damages. And I'll put in the special damage. And I say, so how big a circle do you have to have here? It's got to compensate for the difference between what was and would have been and what is and will be. You'd have to talk about the things that were lost. And as you do, I put, say, 1/8 of a circle. How about if it's a death case, it'd be the care, the comfort, the society, the love, the affection, the loss of this, the loss of that. And then I say, well, the damages to the pocketbook are $2 million. In our computation, that only occupies 1/8 of the circle of justice which you are responsible for filling. And so how are you going to fill it? Are you going to say, make the circle smaller when it shouldn't be smaller? Or are you going to give them the whole amount of money that represents justice? $2 million here, the rest of the circle could be filled with another 14. I'm not a mathematician, but that's $16 million. And so I submit to you that would be justice. That would be a good way of doing it.
Switching gears totally. You're 2 years shy of the 50th anniversary of the Veen firm.
Correct.
So since 1975, you've been successfully running a firm, and it's grown from you sharing one chair with a secretary to where it is now. For those who are running their own firms or thinking of running their own firms, what recommendations would you make to them if they wanted to replicate the decades of success? Not replicate your firm per se, but the decades of success.
Get a good line of credit. That's one of the things is banking. The idea is you have a victory. You feel so good. You got a $2 million jury verdict and you got so much in attorney fees and you've got your costs back and you're satisfied and you're expanding and you hire other people and you get too confident. I mean, because it's for every beautiful sunrise, there's a sunset. So all of a sudden you're doing really well. And I look at it as this large, very voracious, carnivorous animal of overhead. And you're doing really well. You keep throwing hunks of meat behind you. And you notice as you look over your shoulder that thing is getting bigger. And it's getting bigger and it's getting bigger. And then finally you throw a great big hunk of meat. God, I really knocked it out of the park. And you don't have to look behind you for a while. And maybe you get a little careless and you start not remembering that you have to prepare for the bad times. You have to set money aside. You can't just count on it happening again and again. And I tell them that, put it aside. Don't be overly confident. Make the same analysis you would when you were completely poor as you do when you're flush, because you won't be flush forever and you won't be poor forever if you do a good job. So it's that putting aside the money, putting aside the investments so that you can really do everything necessary to win the case. I mean, I've had cases, a brain damaged baby case that I tried with Cynthia McGuinn. I had $500,000 in costs in that case. $500,000 of costs, everything thrown in there. And I was tapping the line. And this was a brain damaged baby case. $500,000 of costs. I think they offered, $250 or maybe, yeah. They offered $250,000 for a brain damaged baby case. And admittedly, it was a tough case. And one of the most embarrassing times of my life really have been because I wanted to introduce the small child to the jury because you're responsible for taking care of this kid if indeed you find legal responsibility. And here's this kid is really brain damaged. He's got cerebral palsy. He was a sort of adorable looking kid.
He was.
And I picked him up like that. And all of a sudden he started going, totally falling apart like he was going to die immediately in my arms in front of the jury in my opening statement. And I passed him, I think to Cynthia, and down the hall, you hear this. I said to the jury, that doesn't look good. I tell you, but I want to tell you something. He's going to be around for a long time. And I'll tell you why. Because he's got the gag reflex, he's got the swallow reflex, and he's got the cough reflex. And you saw all three of those in this moment of time, which means he's going to be able to rid himself of the accumulated body fluids. He's going to be surviving, and he needs your help. So the jury award was $85 million. The present value of that was about $20 million. And I get an offer, a really insignificant offer. And it felt so good. It felt so good to give that to the family too.
The story you tell there, I feel, is a powerful example of a trial lawyer using the evidence that is presented. And that's the thing about trial, is it's real time. So you had a moment and it could have gone one of two ways. And by leaning into it and owning it and discussing it, instead of trying to, ignore the man behind the curtain, you managed to help turn that moment that obviously concerned you into some of the foundation for success.
It was a fun trial. Also, I had the opportunity to try it with Cynthia, who I would give the closing, and she gave a very powerful rebuttal. You can split your closing arguments up, and sometimes it's a really good idea because I might come off kind of brusque, but she came off just perfect, and sort of smooths out the hard part of my personality anyway. So it felt like for a year of being proud of yourself and proud of the firm and proud of the job and proud of your clients. That's why it's such a great thing to be a plaintiff's lawyer. I mean, I've been a defense lawyer, and I remember actually being in a defense firm when I first passed the bar. I was 25 when I passed the bar. That's why I got drafted, basically, almost drafted. And they're sitting there, and I swear to God, this happened. It was a photograph of a bus and a woman and white lines, which were the cross. They were cropping the photograph so it wouldn't show the crosswalk lines.
Wow.
And it was a Corvette that had been rear-ended and burst into flames. And I know there was a film of a replication of that event, which the Corvette was rear-ended and burst into flames, which somehow probably never saw the light of day. I decided that rather not be a lawyer. For my personality, this is what I needed in my life. There are some very wonderful and very ethical defense lawyers. It just would not be my personality in that situation. I know some great defense lawyers. So I lucked out again that I found something that I really enjoy, that I continue to enjoy it. I still get amped about it. I still get excited about it. You see a person that's drowning and you know that you could provide them with the oar, or you could provide them with a flotation device, and the look in their eyes when you come through for them. And they knew that there was no way in hell they would ever be able to do it. And then they come to you and you do the job for them. There's nothing like it in the world.
As we come into the tail stretch of things, is there any other thought, wisdom, knowledge that you'd want to pass on to people who are listening?
Well, I think the thing is, nothing is ever hopeless. I lost one case between 1986 and now, one jury case. I lost a couple on appeal where I got punitive damages tossed back down my throat. But many of those cases that I tried were cases I didn't want to try. The thing about a plaintiff's attorney is you settle the cases you'd like to try, and you try the case you'd like to settle. I guess that's what I would say. I've been in a situation where when I learned, this was early in the game, before 86, I remember getting my one and only a migraine headache because I learned I had to try the case. And the guy that gave me the case, who told me I had an expert, was lying to me. But I now represented the plaintiff. And I had to try that case to a jury. And it was a horrible feeling. But yet I learned from it. Not only did I learn from it, I grew from it. You grow from any case you come in contact with. You grow from any association you have with juries because they're just people. And you'll see from that, you'll learn some of the things about how you spot potential defense juror and how you mannerisms and what have you. It's hard to explain, but you get the feeling for it. And take the risk, take the chance, try the case. Don't let your ego get in the way of being a hero, because it's so comfortable sometimes just to take the money and run. And maybe you go to Hawaii, you take the settlement, but you know it's not right. You know you could do better. Well, do better. And that experience of taking the risk will make you a far better lawyer and make you able to win case after case after a while. There'll be a long string of victories. And when it does happen, when you lose, which you inevitably do, you'll just feel bad. That's the one you'll remember more than anything else, is the one you lost.
Bill, I really appreciate you coming on the show.
I appreciate you as both a friend, and I feel like I've known you for a long time, and love you a lot, buddy.
Likewise, Bill. Thank you. And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, any suggestions you have on getting into the courtroom to actually try that case, and intersections of third-party and workers' comp liability. Like what you heard? Share us with a colleague and leave us a 5-star review on Apple Podcasts. To all of you doing justice out there, happy hunting.